Hello and welcome everyone to Immigration and Jobs Talk Show. I'm Nipasa, your host for today. And before we start off with today's session of discussion, I have this very amazing guest, I want to read out this very important disclaimer. So, yes, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, once again, thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and on X. So, please feel free to join us by commenting. You can participate with your questions. And yes, we also have a phone number where you can join us. So, all you have to do is call in this number 425-436-6335, and the access code is 988-888. And once you're in, you can speak. We will be able to hear you. So yes, very very excited that our topic of discussion for today is facing deportation under Trump's immigration plans and what are your legal options. I know there has been so much happening ever since Trump joined a week back, and yes, we hear a lot of deportation news, a lot of scare that is faced by a lot of immigrants out here. So yes, if you know someone who's in danger of deportation, this discussion is also for you. So, yes, we'll be talking about the latest legal options, possible defenses, and how you can protect your rights in this uncertain times, and I'm very, very excited because joining us today for the first time is a very distinguished guest, Isadora Velazquez, and yes, an AV rated board certified immigration attorney from ISA Law PA in Miami, Florida. And Isadora has years of experience helping clients navigate complex immigration issues, and she's going to join us, to shed some light on what steps you can take to protect yourself or your loved ones from deportation. So, without further ado, a very warm welcome to you, Isadora. Thank you so much for joining us today. And
Thank you,
how are you
guys.
doing?
I'm doing great. Great. I mean, despite everything, happy that I get to share some information with you and all your viewers.
I'm very excited, and this is our first time, so it'll be very nice to know from yourself about you. So, would you like to tell us more about yourself?
Well, in a nutshell, I am located in Miami, Florida, but immigration law gives me the luxury of being able to travel and represent people all over the world. My niche practice is actually in removal proceedings. So I tend to represent, although we bring investors and I help employees bring and employers bring anyone here into the United States, I mainly help you if for any reason you're getting kicked out. So that's my niche. And that's why this specific topic is so essential to what I do and why it's
And
such a
very,
privilege
very
to share it with
timely.
you. Yes,
Very, very
exactly.
timely, I would say. Yes. So we're very lucky to have you today. And I mean, it'll be so nice to know it from you, your experiences as we, get deeper into this topic of today. So, what can folks out there expect from today's discussion?
So you mentioned it a little bit in terms of experience. We've been through this before. This may seem new because Trump just took over as president, but he was our president back in 2017, and we got some lessons as to what we can expect. Also, we have his campaign promises to follow as a good roadmap as to how immigration may look under his administration. First, I'll start by remembering 2017. And in 2017, the most shocking aspect, at least for me, in the immigration practice was the Trump Muslim ban. Basically, for those of you who don't know, or for those of you who remember, it left many individuals with valid visas out of the United States simply because there was an executive order listing specific countries, for example, Nigeria, and stating that people who were out of the United States, their visas basically were no longer valid. This has created a new warning now for my clients in terms of whether you have a visa here in the United States and if you can travel. I have many clients with H1Bs, for example, L visas, different types of visas, who now, many students who now may be looking to visit their families, see what may happen. So far, President Trump has not signed an executive order similar to the Muslim ban that we lived back in 2017, but we did go through it back then. He did warn us that it could happen again. And most importantly, the Supreme Court here in the United States upheld such an executive order. So I would like to start by warning anyone who may have a valid visa that although it may seem absurd, the reality is that a president can overrule and overturn and basically cancel, revoke your visa simply with a pen stroke through executive order. So keep that in mind when you're making travel arrangements, because it's something that we typically don't consider. We have our visas, everything's fine. And it was rather shocking experience back in 2017. And I would hate for anyone to go through that again during this next 4 years. As to the
Well,
people here,
thank you so much. Yes. Sorry, I interrupted. Please go on.
it's okay. As to the people here, I just wanted to warn. I know that if you turn on the TV, it can be scary, as you mentioned in the introduction. You keep seeing ICE raids, you keep hearing at least about executive orders that may affect people in the United States. I will gladly go into details as to who may be affected by executive order, but I'll start by giving the warning that immigration law itself has not changed in over 40 years. I've been practicing 17 years. It has not changed. What changes are executive decisions that may be temporary and have a very deep effect. Right now, the rates that you are seeing are being targeted to individuals who either have a criminal record or have a deportation order. That is
Mhm.
the warning. However, when it comes to raids and ICE, anyone who may be without status could be subject to removal, and anyone in border states, Florida, for example, anyone close to the border by 90 miles is also subject to expedited removal. So just be careful, but understand that the law remains the same.
Thank you so much. I mean, that was a real great insight, and I'm really looking forward for this whole session ahead of us. So much to learn from you, Isa. So thank you. Yes, and like you've mentioned, ICE, and we've seen like DEA, FBI, everybody joining hands with ICE in this mission to really deport. I mean, you everywhere you're bombarded with news of deportation. So I can only imagine how scary it is for all immigrants out there, status or
Yeah,
no status.
it is terrifying. So for individuals who may be here, the reality is in the United States, the only individuals who are guaranteed entry at least and know that their status is safe are citizens. That is a truth. However, executive orders cannot get rid, for example, of your residency if you're an lawful permanent resident. But for
Mhm.
any individuals who might be fearful as to what are their rights, how can you protect yourself, if you already know you have a removal order, then I encourage anyone to explore how they can reopen. Any removal order can basically laws change, they may change, and you may be able to go back in time and reopen your case before a judge. Anyone who does not know their status because they're afraid of finding out, now is the time to find out. It's best to know now and protect yourself. And lastly, for people who might be pending, it's good to explore what options may be available. You may still be able to seek, at the very least, withholding of removal if your circumstances in your country may have changed. So explore your options. They're out there.
Thank you. At least that was hopeful. Thank you, Isa.
I
Yes.
try.
And I think without further ado, I'm going to move on to the questions that I have, So my first question to you, Isa, is, with regard to the legal grounds, what are the main legal grounds? You've said it's not changed. But yes, when you talk about deportation, especially under this current administration, Trump 2.0.
So we have to distinguish between what is a revocation of a visa, which may be that you're here on legal status and you may receive an email or something letting you know that your visa has been revoked. That is not a deportation proceedings. That is simply warning you that you may not be able to return on that visa status. A deportation proceeding entails, a removal proceeding entails appearing before a judge. Individuals who come in under a status known as ESTA or visa waiver don't have that privilege. They have waived their rights, as the name says, so they will not appear before a judge. Only individuals who may be subject to deportation appear before judges, and these individuals tend to be people who have been in the US for over a certain amount of time, who may have a remedy, and you may appear before the judge because you either don't have the correct status or maybe something happened that affected that status. Under the new laws, and this is a new act that was recently passed by the Senate in the first week of Trump being in office, individuals who have been accused of committing a crime could be held on immigration detainers for ICE to pick them up. So, although they may not end up in deportation proceedings because of the crime itself, because they haven't been convicted, they may end up with their visas revoked or their status in jeopardy simply because of the accusation or the arrest. So, this is the only expansion in terms of who could be subject to deportation. During the campaign, Trump focused heavily on people who were criminals, had criminal record, or had deportation orders in absentia, which means individuals who were supposed to go to court and simply chose not to go to court. Those were the main targets. But we have seen, like I mentioned in the introduction, that when it comes to raids, many people could be subject of the raids, even if they are not part of these two particular groups. So it's good to know your status and know your rights. Know that even if you are detained by ICE, you still have the right to appear before a judge, depending on how you enter the country. And the asylum right is a universal right anywhere in the world. So you can always let the government know that you have a reasonable fear to go back home, but you must show persecution from the government or from an agent that the government cannot control. It's a very difficult remedy, so it's best to explore all the other remedies first and use that one as a last resort.
Absolutely. And I think it's always best to consult with an attorney. And why not contact? I mean, the best for now in this case would be, of course, Isadora herself. And folks out there, she's based out of Miami, Florida. So her phone number is 305-938-0676. And you can email her about your case in case you need help. And her email address is isadora@isalawyers.com, and go visit isalawyers.com to get to know more about Isadora for sure. And with what you just said, I mean, this fear of deportation everywhere and with every individual, every immigrant. So I have my next question. What should one person do? The immediate steps that the person should take, facing deportation to protect their rights.
The first step is to find out your status in the United States. If you've been here for too long, you may not know. It's good to figure out what does immigration have on you. If you maybe submitted an application and thought nothing happened with it, or it's never processed, believe me, if you were submitted, it's there. So it's good to know. And you can find out directly from the Department of Homeland Security by submitting a Freedom of Information Act request that will give you your entire record. So you will know if you have, for example, an alien number, if you have a case pending, if it was denied or maybe approved. It's good to know your immigration status if you're in the country. For individuals who are in the US for more than 2 years, it may sound silly, but it's something new and it's something that you should do, especially if you live in a border state like I do, state of Florida. It's good to have record of how long you've been in the US. I emphasize this because during the Biden administration, we had certain benefits, people allowed into the country of certain countries like Nicaragua, for example, Venezuela, Haiti, Cuba, for 2 years. Now, Trump has announced as of Thursday last week that these individuals or anyone close to a border state could have their parole status revoked. And that is a process called expedited removal, which would apply only for people in the US for less than 2 years and who are, once again, in a border state close to the border. And the border includes the ocean. So it also includes California, Washington State. It's good for you to have your records. So that would be my other advice. If you filed taxes 3 years ago, may sound weird. You may want to carry a copy of that tax return with you to show that you've been here enough time to be able to go through any proceedings if needed, instead of to be placed in proceedings quickly when that shouldn't be the case. Lastly, explore options. And I'll repeat this. This will be a common theme throughout this presentation. There are options available. You may be here, for example, as a student, and you may be able to switch your visa. You may be here under temporary protected status. Maybe you can travel and we can find another status, a more suitable status for you. Find your ties to the US, and let's find a way to make you more permanent in the country so you can rest at ease no matter who's president.
Absolutely. Thank you so much, I mean, for that hopeful message. And yes, look out for options. I think it's always best to do your research, know your rights, know what options you can have, and of course, consult an expert. An attorney would be great. And, I would also like to appeal to folks out there to call us up. We have Rohan, Bhavin, join us. So why don't you also, I mean, we will take up your comments for sure a little later in this show. But what I want to tell out to folks out there, yes, take this as an opportunity that you can call us and talk to Isa herself, and just call us on this number which is displayed on the screen above. And so now, moving on, Isa, I have another question, and that is, how can individuals determine, if they qualify for relief from deportation? And,
I'm gonna
if there is a problem, as you mentioned earlier, then cancellation of removal or even adjustment of status. So how can they know that?
Of course. I'm going to answer your question by at the same time addressing Rohan's question in the chat
Sure.
so that
Okay.
he gets a response. The best way to determine your remedies is to determine how did you come into the country, as you keep emphasizing, Nipasa, and you're absolutely right. Speak with an attorney. And I give the warning that in many of our countries, for example, in Latin America, notarios may be considered attorneys. In the US, they are not attorneys. So you need to be very careful who you seek legal advice from. Attorneys have a license on the line to lose. And also, if an attorney gives you the wrong advice, there are actual legal remedies that you can use to fix your status, get some status in the United States based on that wrong advice because you relied on it. So that's the benefit of speaking with an attorney. The best way to know what remedy you qualify for is after having that consultation, determining how you came into the country. What ties do you have to the United States? For example, if you've been here for a long time and you're placed in deportation proceedings and removal proceedings, you may qualify, as Nipasa very well mentioned, for cancellation of removal. But to qualify for that remedy, you need ties to the United States, a family member. There may be waivers that may be available, whether if you have a criminal record, that would also require a family member. If you were a resident and you may be losing your status, either by a mistake or something that may have happened, waivers are also available that may not require a family member, but will be based on how long have you been here and your character. So because each case is unique, it's always good to have that consultation and know that there are many remedies that are available only if you are placed in proceedings. In Rohan's case, for example, without more information, it's important to know how we came into the United States, because coming into the United States legally, meaning with a visa or being paroled to the United States, meaning they allowed you to come in, may open the door to other remedies. For example, adjustment of status. That's what we call when you change your status, maybe to a residency through marriage. You may marry a US citizen. You may even marry a Cuban resident and acquire status through their marriage, but only if you entered legally. Meanwhile, if you enter irregularly through the border and you overstayed or simply stayed too long, it may be that your only remedy is to seek asylum. If too much time has passed, 15 years or more, it may be that your only remedy is to seek withholding of removal, which means that you are basically trapped in the United States. You're allowed to stay, you're allowed to work, but you won't have the privilege of a residency and you won't be able to travel. So these are little caveats that are very unique to each person's case. And also remember, some of these remedies are only available, sadly, once you are in deportation proceedings.
Right, right. Thank you so much for taking that up, Isadora, and also Rohan's answering to Rohan at the same time. Hi, Rohan. I hope you've gotten your answer, and you can keep commenting and even join us, in fact, if you want to. So, Isa, I want to have ask you to explain a little bit. Why do you think people overstay or they fall out of status and still are in the U.S.? Why not find a solution before that? Play safe.
Lack of planning. I can tell you 95% of my consultations are people coming in and telling me, so I came in as a tourist and what do I do now? And not understanding that as a tourist, you only get merely 6 months. And without a
Mhm.
proper plan, simply coming in as a tourist, it's not like the movies where you can just stay and things will be merry. You need to find a way to adjust your status. Or the other way is minimizing it. People simply minimize the consequences. They think, what's the worst thing that could happen if I just stay longer than I'm allowed? That later on, doors that may be available, particularly employment opportunities that are maybe available, are no longer options if you have stayed out of status. If you are in the US illegally without status for more than 6 months and you decide to leave, you basically cannot come back for 3 years. If you're out of status for more than a year, decide to leave, you can come back for 10 years. Same applies for employment opportunities or other visas that may be available. If you're
Mhm.
out of status for up to the 6 months, you may be able to change your status, apply for an investor visa, seek that job that you want, change your status. But the 6 month mark is crucial. So the lack of planning is essential. We need to avoid that, plan ahead of time. And also remember, there are other options if you still need more time to plan. You can always extend your tourist visa depending on the visa. And you can also choose to become a student, which is a very popular option, which people decide to embark on. It has many limits. You're not allowed to work, which is very burdensome, but it does buy you, at the very least, buy you time until you figure out what do you want to do in the United States.
Well, there you go, friends. I think it's also ignorance. So I think it's always best to do your research, learn more why you're there and what options you have, especially because that's not your own country and you wouldn't want to be kicked out. I mean, imagine, getting yourself paralyzed of options. I mean, greater options. So, yes, play safe and all the best, I would say. So let's move on, Isa. I have another question for you. And, this is, what role do sanctuary cities, they play in protecting undocumented immigrants? And how effective are these measures under federal law?
So we have seen their role a little bit so far in this week. Granted, it's only Wednesday, Tuesday. We've seen it a little bit, particularly in Chicago. Chicago is considered a sanctuary city, and their behavior during the Trump announcements of the ICE raids in the city shows why they're considered a sanctuary city. They were very clear that the local police enforcement would not cooperate with ICE. However, there's only so much you can do. The reason Chicago was chosen to be the model city for these ICE raids is because of the high volume of Custom and Border Patrol officers and ICE officers that were already located in the city. So the city may be an advocate for immigrants and they may be vocal in letting the federal government know that they will not cooperate with them. That does not mean that the federal government cannot come in and choose to enforce the ICE raids as they please. What the sanctuary cities tend to do, and we see this mainly in Chicago, we've seen it, and we see it particularly in cities in California, they promote individual rights. Immigrants in the United States have limited rights. It's not the same as what we see on TV. You have the right to remain silent. That does not apply in immigration proceedings. In fact, they're considered civil proceedings because the penalty of being deported is not considered as severe as the penalty of being incarcerated, for example. So you do not have the right to an attorney. However, when it comes to warrants, having to open your door for individuals to come into your house and arrest you, your boss having to open the door for an ICE raid, you do have rights. And you don't have to talk to anyone that you don't want to. You can always politely ask if you're being detained. And if you're not being detained, you can always walk away. Those are simple rights that everyone should know. Last, and I'll repeat that regularly, they have emphasized the right to a reasonable fair interview, meaning the right to an asylum. So for individuals who ultimate choice may be like they've been here way too long, there's no other remedy available, the right to an asylum is a universal right. And if you're able to express your persecution by the government or an agent that the government cannot control, you have the right for an interview. So sanctuary cities tend to repeat this to the immigrant community so that they know their rights, but they're very limited in how they can control the federal government coming in if they want to.
Very, very important points. And thank you so much, Isadora, for highlighting each one of them. And it's so important, to know your rights. And especially in these trying times, I'm sure people are, so anxious as in what is going to happen. They are all seeking help. They're probably Googling, which is not the right place, maybe right now. So I really hope that folks out there are not missing out this session. And yes, if you know anybody who's in this fear of getting deported or are on the verge, so please share this link with them, ask them to join, and even better that even after this session is aired live, we will still have this. So I hope that folks out there can watch this and don't miss out on the important points that Isadora is really sharing with us today. Thank you, Isa. And let's move on now to my next question. And this is, with regard to folks out there who cannot afford, what legal resources are available for individuals who cannot afford private representation during deportation proceedings.
The way deportation proceedings begin is that you receive what is called a notice to appear. That notice to appear tends to be attached to many documents, including a list of free or low bono providers in your area. So that would
Mhm.
include here in Florida, for example, Catholic legal charities that they work closely with private attorneys. We take on pro bono cases to help people. So if you're ever in deportation proceedings, because you'll receive the notice to appear, we call it an NTA because of the letters in English, know that you will also receive this list of attorneys. When you contact them, keep in mind from former experience, these are my colleagues and my friends, they may be overwhelmed, particularly during this time. But I will also give you the second part. This is going to be a very slow process. At least here in Florida, we're having individuals, which are the final trial dates, scheduled for 2028. So that should give you enough time to find the attorney that fits your needs to create your case. That is very different than what we may see, for example, in individuals during the COVID pandemic or individuals in the border. The border right now is in a state of emergency. Doesn't mean that the border is closed. We still have people coming in and out with visas. We still have goods coming in and out. It means that individuals who are seeking asylum might be forced to get this benefit in Mexico. They're not allowed into the US. That is something, once again, that we lived through during 2017 to 2020 in the Trump administration. Those individuals and other individuals who might be in expedited removal have quick cases before judges and they have to rush to present their case, to hire an attorney. That should be a low percentage. We saw that increase during the Trump administration before. It's likely to increase now, but it should still remain a low percentage. So my point is, look at the list. If you're ever in immigration proceedings and you cannot afford an attorney, look at the list you will receive with your charging document. They may be there, they can help you. And in the alternative, explore how long it will take so that you can find an attorney who can give you a hand. Last disclaimer for anyone seeking asylum. Asylum itself needs to be requested upon a year of entry. So if you've been here for more than a year, you're not seeking asylum itself, you're seeking withholding of removal, and that's based on the fear that you may have of going back home because of the circumstances at your home. So that's something good to distinguish, because sometimes we take a little bit too long to file for asylum and we're out of it, or we get promised that we're going to file for asylum, but we've been here for 15 years, so we no longer qualify. So be aware of the remedy and talk to an attorney. These are complicated cases. It's good to speak with a lawyer.
Yes, yes, absolutely. Thank you so much, Isadora. And I think, we should quickly take up a few questions from our audience, and that way we can jump back to our questions as well. So let's take up Bhavan's question. I've been detained by ICE before, but was released under an order of supervision. If there's a shift in enforcement priorities, could that put me at risk of being detained again?
Pavan, I hope I'm wrong, but if you are under an order of supervision, typically that happens because you may have a removal order, meaning a deportation order signed by a judge, or your court case may have been closed and administratively closed for whatever reason. If you have a removal order, technically you are already part of the priorities that Trump has already mentioned. So you should be very careful. Right now, my point is, if you have an order of supervision, you don't really have status in the United States. They're giving you the courtesy of letting you stay. That's what you have to report every so often. I highly encourage you to find out what exactly happened. How did you get this order? What was the final decision that led to this order of supervision? See if you can reverse it, reopen it, try to find a more stable status. In 2017 to 2020, we didn't see the Trump administration go directly after people with orders of supervision, but we did see them work closely with countries that were not taking people back to revoke these orders of supervision and send people back. I wouldn't want that to be you. So see if you can fix this. An order of supervision is not the best status. And yes, you could be subject to one of the priorities in the future. Sorry.
Thank you so much, Isadora, for taking this up. And Bhavin, if you were happy with the answer, it's great. But otherwise, we would like to know more information about why were you, put under supervision. So tell us more. And otherwise, why don't you contact Attorney Isadora herself? Yes, and let's go on to Anusha's question. I am an Indian citizen who has been living and working in the US on an H1B visa for the past 5 years. Recently, my employer filed for my green card, but the process has been delayed due to the COVID-19 pandemic and the Trump administration's immigration policies. Okay, I'm getting married to a US citizen soon and am worried about my immigration status. What are my options for obtaining a green card and how can I expedite the process given by my circumstances?
So I'll go through each step. First, if you're here on an H1B, you should be okay. As you know, the H1B, and if you don't know, now you'll find out, you have a limit of 6 years. So eventually you need to know how long have you had this visa, and it will only count the time that you've been physically in the United States. So if you're close to the time and maybe you spent 6 months out traveling, you can renew for that amount of time that may be left on the visa. As to applying for the green card, when an employer files for the green card, they have the choice of doing it in an adjustment packet, which would mean doing the petition with the residency petition all together at once. Or the way I prefer to do it is to split up, to do the petition first, get that approved, good for you, and then apply for your residency. And the reason I prefer splitting it up is that if anything happens with that first petition that is not approved, I can fix it. So instead of having it all denied. So it's good for you to know, how did your employer apply for this green card? Did they do the entire packet? Was the petition will be called an I-140 petition for employment, employer petition. If that I-140 was already approved and they filed for your residency, you can relax. You're here pending adjustment. So congratulations on your marriage, but you're okay. You will eventually receive your green card through your employer if the I-140 was already approved. If they was filed in a packet, same thing. You can just simply wait for the decision. But you asked about expediting. If it was filed in a packet and you don't have a decision on the I-140 petition, you also could file through your marriage. You can have many petitions running at the same time. You can have a petition through marriage. You can have a petition through one employer, two employers, three employers. You can have it through many spouses, but you could have it through several employers. So you can have many petitions running at the same time and see which one gets to the finish line first. Typically, we've seen the marriage petitions tend to be quicker. We've seen that. In 2017 to 2020, petitions that were taking 2-3 months during the Obama administration, that were also taking 3 months during Biden, back then were taking 2 years. So I can't guarantee filing through your marriage will expedite it, but it's definitely something you could do, and just have them running at the same time and see which one gets to the finish line first. As long as you file any petition for your residency, which is the I-485 application, as long as you file that application while you're here on your H-1B, doesn't matter that your H-1B expires, the time that you're waiting, you're here legally. And you can apply for a travel permit if you need to go home for any reason.
There you go. Anusha, thank you so much for participating with your comments, and I hope you got your answer. Thank you, Isadora, for taking that. So, would you like to tell us also, how important is the I-140 and the I-485?
So first, I wanted to emphasize that as to the how some people do it, because I know that many of my clients many times want the entire petition together. They want the I-140 petition for the employee filed simultaneously with your I-485. It's very important for you to know which category you're applying under. If you're an EB1, meaning you are, and we're not very creative in immigration, so the letters and terms that we use are very boring. And EB1 means employment based. So when you hear EB for any term for immigration, at least, that's residency based, employment based petition. EB1 are the bosses, the big boss, the one that never answers the phone. He just tells people what to do. If that's your case, then you may be eligible to file the entire packet together all at once. If you're in the second category, which is EB2, that tends to be extraordinary individuals or individuals who are going to be working for the common good, something in the national interest. It's good to you for you to follow exactly. It's called a visa bulletin, and it will have dates letting you know if your application is what they call current or if you're going to have to wait. Because I also wouldn't want you to waste money filing an entire adjustment package with an I-140 and I-45 application for residency only for it to be rejected because your application is not up to date. I can tell everyone here who may be in the most common category, the EB3, which is for the regular day-to-day employee who has a degree and is needed for the economy, but simply can't be found in the US economy to work the position. Those individuals will have to wait. Right now, they're processing the applications from 2022, if I'm not mistaken. It could be 2023. So it's not current right now. So it is best to file your I-140 petition first, no matter what, because you're going to have to wait. And as it is pending, once it is approved, you will know the date when you can file your I-485 application for residency. While you're waiting, you need to keep legal status if you're in the US. Otherwise, you can always do a consular process and receive your green card in your country through the embassy.
Thank you. What? Welcome back once again, everyone, to Immigration and Jobs Talk Show. And it's really exciting today that we are having a great discussion with none other than Isadora Velazquez. And yes, we are here talking about a very, very important topic today, facing deportation under Trump's immigration plans and what are your legal options. Well, thank you so much, Isadora, for being here today and for patiently answering, taking up so many of our questions and making this discussion a very interesting one so far.
It's my pleasure. I see that Prativa had a question about
Right.
overstays, which I asked before, Nipasa. What happens if you overstay? I don't know if you want to read it, and I'll gladly answer it.
Sure, I can read it. I overstayed my student visa years ago, but I've since started a business and contributed to my community. If deportation becomes stricter, can my contributions or business ownership help my case? Pratibha is
Under
asking.
the law, and like I said before, this is over 40 years that the law has not changed. Your contributions while out of status will always be beneficial. The same, it's called the ties to the country. So the contributions, your business, any family you may have, the amount of time you spent in the United States will always be, they will be considered beneficial factors for you to present your case. And depending on how long you've been in the US, you may qualify for some things that we discussed before if you're placed in deportation proceedings. Now, please understand that contributions alone are not sufficient for you to seek a legal remedy by yourself. It might not be enough. So you may need a little bit more than simple than a business. And I'm not doubting your business is very successful. I'm not doubting they're contributing a lot, but you may need more, especially if you want to seek business by yourself, if you want to seek a visa or more control by yourself. So the ties tend to prefer family ties. Business will definitely help you fight for your right to stay, but it might not be enough to actually win your right to stay. So keep working on it, keep building it, and in the end, they may help work on your favor.
Thank you so much, Isadora, for taking that up. And Pratibha, I hope you've gotten your answer, and you can keep asking more questions if you have any further questions. So, Isa, we also have more questions from our Facebook group. So I think we should quickly address them, and then when we get time, fall back to our questions again. So, Control, if you can display them, please. Let's take up this first one. This is from Krishna asking, hi team, H4 to F1 transition. Could you please zoom in a little bit? What are the best options to choose for changing to F1 from H4? Her F1 visa is rejected in India and she came back to USA on H4.
If the F1 visa was already rejected at the embassy, the F visas, and for those of you who don't know, the F visas are student visas. The student visa, in my humble opinion, should always be processed by the school that is issuing you the visa. As international students, you will end up paying much more than residents or citizens of the United States. And the reason why your tuition is so much more expensive is because the school has to be heavily involved in the visa process. They have to apply for the visa for you. So if for any reason India rejected your F1 visa, you can always choose to change your H4 status in the United States locally to an F visa. The big caveat here is that when you choose to travel for any reason and you go back home in India, you'll need to get your F1 visa on your passport. That's the difference between what we call a change of status, changing your status from H4 to an F1, than to acquiring status. You cannot come back after you change your status under an F1 visa if you don't have it on your passport. So you will have to go back to the embassy. They may reject it again. Very helpful to know why they rejected it so that you can fight it here and be ready to get it again after you change your status in the United States.
Thank you so much. And I hope, Krishna, you've gotten your answer. I think this was a question for somebody else, but yes, great question. Let's go on to our next one. This is from Sachin. Hi, all. I am currently on STEM OPT with my end date in February 2026. I have one more chance to apply for the H1B lottery this year. If my H1B gets picked and approved, will I be able to travel to India in August and return to the US by October 1st? H1B deactivation date.
So I'll explain the H1B lottery visa process. You will know if you were chosen by this lottery basically by April. You should know by April. And hopefully your employer will be applying for your visa by the summer before August when you leave, because ideally you will be coming back to the United States after your trip in August by September. So to answer your question, yes, you can leave in August and come back in October. That's perfect, but you may want to come back a little bit earlier, maybe a month earlier before what we call the fiscal year starts, and get settled up, find the apartment, get set up to begin working. And you should be allowed to return in September if you're picked up in the lottery for April. So good luck. Hope it happens.
Yes, all the best. Since it is lottery, I think you need all the luck. So, all the best, Sachin. Let's go on to our next one. This is from an anonymous member. As an H1B holder, I avail Medic Aid for children and premium discounts. tax credits from state on health insurance purchased via marketplace. To my knowledge, it doesn't fall under public charge category. And will this cause any issues in future visa extensions or green card process? Any expert opinions are appreciated.
Great question. The marketplace, also known as Obamacare, is private insurance. The only reason it's called the marketplace, Obamacare, is because of the law that forces these companies in private insurance to give us that insurance, even if we have pre existing conditions, and for the government to subsidize that insurance if we cannot afford it. But it doesn't mean that we're not, it's a private company. So shouldn't affect your public benefits because you're not receiving any public benefits. I would encourage you to try not to accept any government subsidies when it comes to paying. If you can pay it out of your pocket, that would be best. But feel free to use the marketplace for your insurance needs. You're entitled to it. You should be okay. It should not affect your any visa or future green card process.
Great. Thank you so much for taking that up, Isa. Let's go on to our next one. And this is also from, okay. My H1B extension was submitted on August 2nd, 2024. H1B expired on September 30th. Until today, it's been in review status with no update.
You have the option, and you may not like it because it's pricey, but you have the option of contacting, paying $3,500 more. It's called premium processing, and that will force the government to give you a decision on the extension in 15 days. Make sure you have the option available. You have to let them know ahead of time, send them a check. It is a good option if you want peace of mind. However, technically, under the law, during the time that you apply for the extension, it's the same as when you're applying for a change of status. So you are technically legally in the United States until a decision is issued. So be on the lookout for that decision. If you really want the peace of mind, it's worth it to pay a little bit more, but be aware that technically under the law, you should be okay until you get a decision.
Okay. Thank you so much, Isa, for taking that up. Now let's go on to our next one. This is also from an anonymous member. Planning to travel with family from US to India this year after a long time. H1B, H4 visas have expired on our passports, but have approved extensions, I-797 petitions. Travel costs seem exceedingly high to travel with family, but routes via Europe seem relatively on the lower side. Question is it possible to travel via Germany or UK, etc., with an expired visa? And the second question is, would a transit visa help? And next is, don't bother, take a different route.
The answer I'm going to give you what they will call in the US a very legal answer. It depends. What are you coming to do in the United States? If you're coming to work, you can use your H1B, H4 expired visas because you already have the extensions. It doesn't matter if you come through the UK, Germany, it doesn't matter. You should be okay because you have extensions on your H1B and your H4 visas.
Mhm.
However, if you're coming as a tourist, you will be asked why you're coming to the United States. So if you're not coming to work, then yes, the best way would be to apply. I wouldn't call it a transit visa. I would call it a tourist visa. What we also call it the B1, B2 visa. B1 is for employment purposes when you come maybe for trainings or for a conference. B2 is when you come to visit Disney World or to check out how California is doing. So if you're coming as a tourist, that's the way to go. If you're coming to work and your visa has been extended, you should be okay. Doesn't matter where you come from.
Okay. Thank you so much, Isa, for taking that up. And let's go on to our next one. I think this is the last one from our Facebook groups. This is also from an anonymous member. Recently got a Canada PR and have H1B job in Seattle, 2 days a week in office. Employer doesn't care if I spend remaining remote days in Canada. So for H1B stamping, is it okay to disclose I may work remotely from Canada regularly or occasionally? Wondering how to answer the question, will you be working remote or hybrid from your work location?
Answer yes. And the main reason I would say answer yes is because now that you have the permanent residency for Canada, you may be seeking a more permanent status in Canada. And you'll find out that once you have Canadian status, you can come in and out of the US for 6 months per year, no questions asked. It's actually very flexible. The being candid and honest now, letting them know that you have your Canadian permanent residency, that you will be working remotely from Canada, will also help them relax a little bit whenever they see you and asking you questions if you choose to come in through the Canadian border. So answer yes, you will be working remotely. That's still your H1B visa was still approved under the same conditions, so it shouldn't be an issue as you come in and out through the border. You'll also notice that the Canadian border is very flexible. If you have to renew your visa, you can do so through ports of entry through that border. So it's good to be honest with them and letting them know that you're spending time in your new home of Canada.
That's great. That's great. Thank you so much, Isa, for taking that up and so patiently answering each one of our group Facebook group questions as well. Yeah, and brings me to another question that I have for you. I have prepared some more questions, and this is with regard to mixed immigration statuses. So families with mixed immigration statuses, can they take proactive steps to prevent separation or deportation under the current policies?
Yes. So if you have children over the age of 21 who are US citizens, I don't care if your mom and dad don't want to live in the US. If you are in the United States and you're over the age of 21, give your Mother's Day, Father's Day present by simply filing for your parents. The reality is, children, we have the control. It's our petition when we're petitioning for our parents. So we can be proactive, we can file for them. And later on, when mom says, I don't want to move to the US, I don't like that country, it's okay. At least you tried. You have it there. It's ready just in case. If you're in the United States, you can also file for your parents. And if you enter the country legally, it doesn't matter if you entered 20 years ago or actually 22 years ago and you were born the year after you entered, you will be able to give your parents legal status through this petition. So for children over the age of 21 who are US citizens, petition for your parents. For spouses, any spouse who's a US citizen can petition for the other spouse immediately. They can get them status. I say immediately because technically under the law it should be available immediately. You may have to wait a couple months until it's processed. So if the individuals are in the US and they came into the US legally, you will be able to help them adjust their status to a residency fairly quickly. If they came through the US illegally, meaning through the border or something happened, they may qualify for waivers. These waivers are scary because they force you to leave the country, leave the United States, and get your residency in your home country, but they're worth it because if you already qualify for the waiver and you're approved by the time you leave, it should be just coming back with your green card. Scary to leave, but definitely worth it. Now, Trump knows this is happening and he warned us. Part of his campaign promises were that he was willing to separate families that were mixed, as you mentioned, individuals who may have children in the United States, but the parents don't have status. And he warned us of this because back in 2017 to 2020, we saw family separation in the border as a deterrent for people not to come in. So he knew that it was going to be very shocking for, especially for US citizens, for his voters, to see people, to see children separated. So I know it is extreme, but I have been warning my clients to, if you know you're going to leave your child or you may be forced to leave your child, or that could happen, that if you have an encounter with immigration, your child is a US citizen, but you are not, it's good to have a plan. So I hate to send that answer in a sad note, but it is helpful to have a plan. Who will care for your children? Power of attorney if you may need it, because he has made it clear that he's willing to go forward with this, even if it's something the U.S. Citizen is against. It was part of the campaign promises, and so far he has delivered in the past 2 weeks.
Thank you, Isa, for that insight. Really, very helpful. And now let's move on to our next one. We see that there are a lot of changes. It's just been a week with Trump hitting the office, but then how have these changes, whether you talk about visa or green card policies, how have they impacted these deportation risks for non-citizens in the U.S.?
So the main impact that we've seen, of course, is fear, because we don't know. And that's why I start by always warning everyone to at the very least know your status. And after you know your status, meaning know if you have a deportation order, know if you have been in here illegally but you entered legally, and you have a business here, you have a spouse here, you have a child here. Know your circumstances, know it well so that you can present it. Know your country. So know that if you have an encounter and they want to send you back to Nicaragua, now there's a dictatorship there. You cannot go home, and then you can articulate the reasons why you cannot go home to you, not to the country in general, to you. They will follow me or persecute me because I am a woman, because I am gay, because I am religious, whatever it may be. Make sure that you are able to explain it if needed, because that's what we've seen, that these are encounters that, although he warned they would happen, people are not ready for them when they do happen. Lastly, if you have the relationship with your employer in which you can be fully honest with them and have them understand both your rights and their rights, an employer is very limited sometimes in their rights depending on their state. For example, the state of Florida gives a lot of leeway and authority for inspectors to come into my workplace. So there are limits, but you typically require a warrant. And if typically a warrant is not available, these ICE visits, these ICE raids are done on a whim. We assume this person's here. Or maybe they may be looking for somebody else who's not you. So
Mhm.
request that document. It may seem simple, but it's important and very helpful.
Thank you. Thank you, Isa, for taking that up. And, now that everybody is facing a lot of, fear of deportation, what would you advise, employers of undocumented workers who are really concerned about potential workplace raids as well and deportations? What do you suggest they do?
For the employer on a personal level, I know the concern, for example, Florida, the main concern is whether we're going to be fined, and the fines can be steep, but the fines are available everywhere, doesn't matter where you are. And they tend to be related as to having individuals work for you who don't have the proper documentation. What I've noticed in the past, doesn't matter the president, from Obama, from George W. Bush, that's when I started practicing, to the now Trump, when you're able to show that you've consistently paid the correct wages, meaning that you were not underpaying your employee because of his status, they tend to be much more flexible with the fines. They tend to lower them because they understand that maybe you hired out of necessity, which tends to be the case, or maybe you hired out of ignorance. You didn't know that you had to request all those documents to hire somebody. Now, to protect your employees, a warrant is needed to enter your place of business. In Florida, an inspector can enter your place of business to check out if you have 25 employees and to determine if they're here legal or not. That's a local law. But under federal law, to enter your place of business, it's like entering your home, and you can reserve the right of admission. You can call your business a club, and you can simply say, I'm not letting you in unless you have the warrant that forces me to let you in. And check out that warrant. May be able to give that employee a warning, a heads up. For employers, the reality is that we know when they're coming. We know, and they tend to come to us normally not for immigration reasons. So if you have a heads up, be nice. Let them know, and they'll be out of there.
That's a nice one. Thank you so much, Isa. Yes. And I have another question, and this is with regard to legal protections. We've been hearing a lot of raids in schools, even in worship places. I mean, recently, even a Gurudwara was raided in New Jersey and New York, I think. So, what legal protections are in place for students and families affected by school raids, and how can, these institutions respond to such incidents?
Well, sadly, the same way I started with the sad news that president can get rid of your visa by simply signing an executive order. In this case, sadly, for the legal community, for the immigrant community, the legal protections can also be eliminated by signing an executive order. President Trump recently signed one of memorandum executive orders saying that ICE raids can occur, as you mentioned, in schools. They can occur in hospitals. However, there are some places that tend to be considered places of business, and they can be protected. Churches are the most common one. So you can seek protection there. That would be, we're talking here of extreme cases, but we've noted that tends to be where people feel the safest. And in reality, that is another place in which you would need a warrant to enter. But public
Mhm.
spaces such as schools and hospitals can no longer afford the protection that we typically associated with these areas. So we have to be mindful. A little trick: when we have minor children, we sometimes don't apply for them to have a work permit because they're little. Why are they going to work? Who cares? But now I find myself warning my clients that it might be a good idea to have their child, if they're here on a status that may be temporary, like temporary protected status, or even under particular visas like the HV. Of course, your child's not going to work, but maybe you want to pay the $500, $600 and get that work permit so that he can carry that ID showing that he's here legally. It sounds weird and not needed because it's not needed, but these rates are terrifying even for attorneys. And the fact that they can go into schools, I would like to protect my child if that were the case.
Yes, for sure, for sure. And well, talking about Miami and your place out there, I'm sure it's been very busy. I mean, the past week must be crazy. How is it? Would you like to share some cases or incidences? Anything you want to share with us would be great.
So Miami has one particularly notorious ICE station. It's called in Miramar, and it's fairly busy. Typically at 9 a.m., we have people who will be showing up in orders of supervision. During the Biden administration, it became routine. They would get a new number. Miami also has the little little caveat, or the little additional flavor of the Cuban community being very, very famous here. We have a lot of Cuban communities, many Scarface, believe it or not, from that back in the day. It's very interesting that many countries that back then were not accepting people, deportees, I emphasize Cuba in particular. Now you're finding that when you're reporting, there is a sense of fear that Cuba has accepted deportees since the Obama administration. That's something that changed. It has since stopped during this Trump administration, Venezuela, Nicaragua. So we have this new flavor of people who are coming in with deportation orders, order supervision in the morning, who are routine up to the point, and then you have the second wave that comes during the day, and that's where we see the ice rates. And it is a little bit like Top Gun, the Miramar station, but it's not as cool. We don't have good looking Tom Cruise looking guys. It's just a simple building with no windows, very terrifying. But we do see the wave in the morning of the people reporting who regularly report, and in the afternoon we see the effects of the ice rates that are very notorious in Miramar.
Well, I think, well, all I can say, it's getting scary, and I think it'll be best to stay safe. So, maybe last but not the least, if you could wrap up by giving a few tips to folks out there who are facing fears right now, and tell us what should we do next.
I'll begin and end with the same note. Anyone who is subject to removal, who may not have any legal remedy, maybe you have a deportation order, maybe you already tried to reopen that case and you failed, maybe you appealed it and you failed too, you stayed too long, you came in through the border, there's really nothing you can do. Asylum, you may not be able to qualify for asylum itself, meaning you won't get a green card, but the asylum right, the right to seek asylum, protection from going back home, is a universal right. So you can always say, I'm sorry, I messed up. I've been here for 25 years. I have no papers. You're absolutely right. But I'm terrified of going home. And this is why asylum must be from the government or from an agent that the government can control. So if the police is going to be looking for you because you're a girl and they don't like girls and you know it, and you can say, hey, my country, women are persecuted and I'm a woman, verbalize it. Second, and I've mentioned this before and I'll mention it forever, at least for the next 4 years. Know your status. Sometimes we ignore it because we're afraid. We think if we ask, we're going to expose ourselves. It's good for you to know. By knowing how you came in, you may be able to fix it. Deportation orders can be reversed. The law changes. People may get deported for something they did 10 years ago. The best example, marijuana. Huge deal in the 60s and 70s, not as much right now. So if you were deported in the 80s because you were smoking a joint, maybe now you can get rid of it. So it's good for you to keep that in mind. Know your status. Know your
Mhm.
family. Who do you have in the US? Siblings, you may love them. Aunt, auntie, uncle, you love them. They're not going to give you anything. You want your mom, you want your dad, you want that. Siblings, they may give you something, but it's going to take like 20 years. So and you want your children. So know your family and keep being like your listeners. Keep growing your businesses, keep growing your ties to the US. They may help you if you end up in deportation. Remember, asylum is a right. You can ask for a reasonable fear interview. Just remember that if you forget everything else I said.
Thank you so much, Isa. That was really very helpful. And I think if we still got some time, we should take up Ansa and not leave her without an answer. So Ansa's asking, what can I use as ID for my daughter who is a pending H4 dependent visa? And can the letter I received from USCIS be used as evidence?
Yes, Ansa, it can definitely be used as evidence. Anyone who has any letters from immigration, make a copy, keep them with you. It's good to have them, especially if that letter has any dates for over 2 years, because then you will not be subject in the worst case scenario. You would not be subject for something called expedited removal. So keep that in mind. You can use that for the time being. You can also check in your local DMV department what they can accept as documents for your child to get an ID, and maybe they can get our local state ID. That would make it easier for all of you.
Thank you so much. Thank you for taking that up for Ansa. And Ansa, I wish you could join us on call. But yes, if you're still available, 425-436-6335, and the access code is 988-888. Join us. But nonetheless, it's been a really very insightful session so far, Isa, and really great having you. It's our first episode together. And folks out there, you can call Attorney Isadora herself, and you can also email her with regard to your case, your status, and with all the details, write to her. You can call her on her number 305-938-0676, and her email address is isadora@isalawyers.com, and go visit her website www.isalawyers.com to get to know more about Isadora. Well, do you still have anything else to share? I mean, this last week, do you have any deportation case that you're dealing with that is interesting that probably you want to share with us?
Yes, yes, I do. I have many of them actually. And that's why I started by mentioning that many of these cases are being reset. What we notice is some judges, Miami is a very busy jurisdiction, as you can imagine. So we have some judges resetting the final hearing dates for 2028. These notice in the mail, if you are to be placed in deportation proceedings, you could receive a notice in the mail where we mentioned the notice to appear. And it will have a date in the bottom. And it may seem very simple, minimal, something that you may want to ignore because what's the big deal? Don't ignore it. It's best to show up, even if you don't have an attorney. It's best to show up and simply ask for more time. Most judges, 99.9% of judges will give you time to find an attorney to move your case along. If you talk to an attorney ahead of time, they might be able to explore options to close your case or maybe see if there's something that can be done so you don't even have to show up. But most likely you will have to show up. So it's good to just simply go. Don't ignore it. As to interesting cases, that's where it's good to know that the law itself, once again, has not changed in over 40 years. I'm getting the same cases under the Trump administration that I would get under the Obama administration. What changes are the discretion that some prosecutors may have. So it's good to have a good report with the court. And what I'm finding now is that simple cases that are maybe, it's a deja vu of 2017, simple cases that I would have gone dismissed or resolved because I gave the example of marijuana. Not a big deal right now, big deal before. It could definitely get you deported. Now I find that prosecutors, and it's not a fault of their own, I don't have the privilege of negotiating with me and getting the case dismissed or getting the case closed. So it's good to speak with an attorney and show up no matter what. Even if you're alone, show up. The judge will give you more time and you will have time knowing that cases might be set for 2028. So you have 3 more years to figure out what we can do for you.
Yes, that is it. Thank you so much. Thank you once again, Isadora. It was really, really very insightful this whole session today. And I wish we could go on speaking, but I will save some, so that you can join us very soon again, maybe discuss on another very important topic. Since changes are happening, it's just so dynamic. Every day we hear new news. Everything is, popping up every time, and everywhere we see is Trump, and whatever Trump is doing is affecting so many people out there, immigrants, America, or even the world. So there we go. So I hope that you can join us soon again, and thank you. I hope you have a great day ahead today.
I would love to join you, please, whenever you need me. Lastly, for your audience, you may hear about getting rid of the 14th Amendment, which is the birthright citizenship. That is still
Yes.
pending. The Supreme Court is likely to hear it. So the law remains people who are born in the United States are citizens as per the Constitution. Just last thought of the day.
Thank you for that. Thank you for that too. Yes, I think we're going to hear soon about that also, probably another 10, 11 days we still got in hand. And let's just keep our fingers crossed until then. Thank you so much, Isadora. Really great having you. See you soon.
Same here. Take care.
You too. And folks out there, thank you so much for joining us. And please feel free to contact Attorney Isadora herself. And you can email her, you can even call her up. Go visit her website as well. And her website is www.isadora at, sorry, isalawyers.com. And you can email Isadora at isalawyers.com. And you can call her up also at 305-938-0676. And you can also call me. You can even WhatsApp me. I have a phone number 408-335-6444. That's my number. And you can also email me about your case. And, that way I can forward the emails to Attorney Isadora also. My email address is nipa@staffingly.com. Thank you so much for joining us today. Y'all out there have a great day ahead, and stay tuned on Immigration and Jobs Talk Show, because at 4 p.m. Eastern Time, I'm going to be back with my co host Sam on Daily Immigration Dose. And yes, keep watching our space. Have a great day. Bye bye.